Thank you both. We'll call the next case Becker versus UCF. Just give council an opportunity to sit down and we'll get started. Council, you may proceed.
Thank you. Good morning. Andrea Mogensen for Appellant John Becker. If I could reserve 5 minutes for rebuttal, I'd appreciate that. This case seems to be very straightforward to me. We're here because John Becker requested from the University of Central Florida records that were made or received in connection with the business of the University of Central Florida. And the proceedings were somewhat distracted by a downstream contract that our opponents have put forth as determinative, but in this circumstance, the trial court erred, in our view, by applying the wrong standard. When
Do you agree or disagree that simply because the records are, let's say, in the possession of a public entity, do you think that that necessarily makes them public records subject to disclosure?
Absolutely not. The location of the record is not determinative. It's a factor insofar as the University of Central Florida in this circumstance made and received the records. It so happened to be in their own facilities, but it's not a bright line test.
Do you think that the factors that are talked about in the Schwab case apply when the records are held by a public entity as opposed to a private entity or individual?
I think that's exactly where this broke down. I think Schwab only applies when a claim is made that records should be obtained from a private entity. In this circumstance, Schwab doesn't apply because a public entity held the records. It's our argument that they maintained and created them as part of their business. And the facts in the record that support that are that Dr. Wright contracted for his employment to bring that journal to the university and received remuneration for it. He received a reduced teaching load. He received access to graduate students. He was given offices that were 100% financed by the university. The university appears on the actual published materials. The business is academic.
If a professor brings to the university the fact that he is editor of a journal, and so the university finds that to be attractive in terms of the quality of their faculty. Is the mere fact that they give him as part of they negotiate with every faculty member in terms of pay, in terms of how many courses they're going to have to teach. Why does one have to impact the other?
Well, in this circumstance, the impact is that it was the business of the university. It was in the context, in conjunction.
The journal certainly wasn't the business of the university. He had a contract,
right,
with the journal, completely unrelated to UCF.
That's where I disagree. If it were completely unrelated to UCF, he wouldn't have signed it.
UCF a party to the contract?
He signed it as a representative of UCF and committed in that contract to providing space at UCF, graduate students from UCF that would be paid by UCF and given tuition waivers by UCF.
But the graduate students weren't paid to work on the journal. They were paid simply to assist him in perhaps this project and in other work that he was doing as well.
Well, they were paid to work on the journal because they were paid and they did work on the journal at UCF. They were paid by UCF to be managing editors of that journal. And the fact that they could have been assigned to something else is somewhat irrelevant in my view. The University of Central Florida financed the entire editorial operation. There is no evidence to suggest that Elsevier paid any rent or paid for any materials, any of the things that a business pays for to conduct the business. The business we're talking about is academia. And this is an academic journal, and that's what universities do, is academia.
Your position that simply because this is an academic journal and he's an academic, that this would be within the statute as in connection with the transaction of official business of the agency?
Not exactly. What our position is that because the university negotiated with this individual for his employment to bring the journal there in an exchange in the context of his employment at the university to have a reduced teaching load without reduced pay, in the context of his employment to supervise graduate students that the university would give tuition waivers to, which is only available from a statutory point of view for university business. That in this particular factual context, it was a condition of his employment. He was evaluated and given evaluation points for tenure based on performing these services, editorial services at the journal at the university. That it was university business insofar as all those things were negotiated in Dr. Wright's employment, but Elsevier was never in contract with the graduate students. The graduate students were in contract with UCF, and they worked on the journal, and the records that Mr. Becker requested cover those emails in between the managing editor and Dr. Wright in his position as a university professor supervising graduate students. So the records request was directed at the University of Central Florida, clearly for business that they were doing in the University of Central Florida. It cannot be said that those graduate students were employees of Elsevier. They were employees of the University of Central Florida. And so that's why we think that the records request is directed at records that are in the possession of and in connection with the business of the University of Central Florida. There's really two pieces to the journal. There's the editorial piece, which was performed by the University of Central Florida students and faculty, and there was remuneration for the faculty for that, and it was negotiated for at the outset of the employment contract. And then there's the hard publishing, which is Elsevier. But, and because the University of Central Florida seeks not to disclose its records, they're saying now, in the context of litigation, well, that all belonged to Elsevier all along. But in the context of getting the travel paid for, the hard office paid for, the computer paid for, the phones, the internet address, the employees, the staff, the managing editor, that was all University of Central Florida. And in those contexts, in the documentary evidence in this case, it shows that those were work-related for Dr. Wright and that the university paid for them for that reason. They didn't pay for some private business, for some outside activity. They paid for university business.
Help me understand why the Schwab factors are inapplicable to this case.
Well, for the answer to that, I would look to the NCAA case. In the NCAA case, it's almost on all fours with this insofar, the Florida Supreme Court said there, these records didn't become public records via the Schwab factors. It came by a much more direct route. The definition of public record in 119 sub 12 is documents, regardless of form, that are made or received in connection with the business of the agency. And that's how these records are records. And that's where I think the trial court erred here, because initially, to determine what's a public record, we should look to the statutory definition of public record. When you're talking about a private agency, that's clearly a private agency, you may end up doing a Schwab analysis if there's some allegation that that agency subbed in as an agent. If that business subbed in as an agent of the government agency. In this circumstance, that's not the case. The argument that's been advanced by Becker from the outset is that this was university business conducted by the university, and that the Schwab analysis does not apply. If you applied the Schwab analysis in the NCAA case, you'd come up with an opposite result, and the Florida Supreme Court did not do that. In NCAA, the Supreme Court said, yes, it's undisputed that the NCAA is a private entity that is not ordinarily subject to the Public Records Act, and they didn't look to all the different teams the NCAA managed, all the different activities NCAA did outside. What they looked at was the nature of the records, and in that context, the nature of those records were in conjunction with university business. And like here, at that point, the USF advanced the argument, well, athletic performance and athletic discipline really isn't the business of the university. And I would suggest that athleticism is more far removed from the business of a university than academic journal editing that is a requirement of tenure and is evaluated by the university and suggested by the supervisor of Dr. Wright as being work-related. But even with it being more remote, the Supreme Court said, no, that is university business. And when the agents of the university use those documents for university business, when they receive them, in university business, they became public records. In this circumstance, a significant number of the records were made at the University of Central Florida with university business because they were email exchanges between employees of the University of Central Florida, some exclusively employees of the University of Central Florida, and in that context, those records are public records by definition, by statutory definition.
Dr. Wright sat on several different boards. Sitting on those boards was part of his evaluation for tenure and whatever else. The university knew that. Is every piece of communication that he has on his university computer likewise a public record for all those other boards?
Absolutely not. I think the variation between this and the other boards is in this context is really that the editorial operation was housed in the University of Central Florida. And now, in retrospect, we want to say, well, that just means he works there. Well, housed means that's where it lives. And the operation was there. One thing that the University of Central Florida has never really addressed, and I do not think they can get around, is that the university hired the graduate students to be the managing editors in a significant number of the records that are requested, if not all.
I don't think that the record supports that. I think that that the graduate students were assigned to this professor to assist him in whatever manner that he wished to utilize them.
He came up with the title of managing editor because he thought it would look good on the student's resume in the future. The university didn't have a check to John Doe grad student dash managing editor, did it?
No, but I don't think that's the determinative factor. I think what the determinative factor is when those grad students were working for the university and were being paid by the university, they sent and they received documents. Those documents are public records. That seems to me to be the definition of public records. The graduate students are sitting at the university working on public business. And irrespective of whether they're Elsevier's records or someone else's records, if they're working on public business, if they're paid by the university to do it, and they're university employees and they're getting tuition waivers for it, which necessarily must be university business, then the records that pass through.
Any email that he gets, because he's paid by the university, the professor is paid by the university, that logic would extend to anything that he received as well. And so the earlier hypothetical asked by Judge Edwards seems that your answer of no, that the other boards wouldn't be disclosed as public records, it seems that should really be yes, because he's paid by the university, it's housed at the university, everything's received at the university. It just seems that the same answer would apply there.
And perhaps I've been unclear because that's not what I mean to say. I think the definition, the statutory definition, is whether or not it's university business. And what is the business of the university is defined statutorily as the mission of the university. And the mission of the university, the business of the university, it's not a private business. It's academia. That's what they do. And they've defined it statutorily as research, publishing, teaching, all those types of things.
The business of the university.
Pardon me?
The journal was not the business of the university.
If the journal was not the business of the university, it becomes very unclear why the university negotiated a reduced teaching load for Dr. Wright at the same pay to bring the journal there. It's unclear why the university would provide.
They negotiated to bring the journal there. I mean, it was coming with him, and that's, that's a part of his resume.
Right, until in billing for the journal, the university letterhead is used. In giving receipts for the journal, the university tax ID is used. Until, when the money is collected, it's put in the Department of Sociology slush fund account. Until the brick and mortar operations, to the extent they exist, are paid for by the university. Until the managing editor for the journal is paid for and provided by the university. I mean, those are the things that make a business a business. The things that make a business are who controls. Elsevier isn't claiming they had any editorial control. They didn't. The editorial control was at UCF. They published the materials. The editorial operations were at UCF, and they were paid for by UCF. They were negotiated for by UCF. And Dr. Wright said that very clearly when he asked his supervisor for travel reimbursement. He pointed out, this is the business of UCF. When he went to fill out his forms, his supervisor said to him, yes, this is work-related. This is the business of UCF. when he was evaluated, and they gave him points for doing it. It was an expectation of UCF that he do something. He elected this activity to fulfill that responsibility. Yes, he could have elected other responsibilities to fulfill, other activities to fulfill that responsibility, but the fact is, this is what he chose. And it's not so much what could have been or what else he could have done. He did choose to fulfill his responsibility as a tenured university professor by performing this activity as his university business.
Do you assert that every club, organization, whether it's a religious club, fraternity, any kind of student organization that utilizes physical areas at UCF, would all of their documents and records therefore be official business because the university is subsidizing them?
I don't think it's really a question of subsidy. I think it's what's the question of the business of the university. And I think there's a factual foundation that's overwhelming.
Well, if you look at the mission statement of the university, it's hard to imagine anything in the world that's good that's not part of their mission statement. I mean, certainly you would think of universities as having clubs and organizations and fraternities and societies and whatever, and you would expect them to conduct their business at the university. But you don't think of that as university business, do you?
Well, I think because Dr. Wright, in the context of his employment as a university professor, was required to perform other activities, and this is the one he chose to do, and because he negotiated on behalf of UCF, with also...
If this was the only thing he did, you may have a stronger argument, but he sat on several different boards and societies and things in the community, didn't he?
Yes, but sitting on a
Didn't the
board,
graduate students assist in those other endeavors as well?
they had to reimburse,
Did the graduate students assist in those other endeavors?
the record shows that in from a record point of view, the very limited amount of time, if graduate students were used for something else, they had to pay back, and it was paid back to the SSR Journal. That's what it appears. The monies that were billed out that went into the sociology slush fund with the UCF tax ID were apparently for renting out the graduate students that were supposed to be working on the journal.
You're down to about 3.5 minutes.
I'll go ahead and relinquish and save my time. Thank you.
Thank you.
Good morning, and may it please the court. Jeff Kuntz from Gray Robinson, here with Rick Mitchell. And with the court's permission, we'd like to reserve 13 minutes for UCF and 7 minutes for the co-appellee, if that is okay with the court.
I'm not sure that I understand. You want 13 minutes and you want them to have 7?
Them to have the remainder of the 7 left.
Okay, gotcha.
But of course, if the court has questions outside of that schedule, we will do whatever you wish. Your Honor, to quote the second DCA, this case demonstrates that Chapter 119, although permitting broad access to public records, is not an ideal tool for private citizens who wish to investigate the non-governmental activities of government employees during working hours. The trial court in this case conducted a 3-day evidentiary hearing with many witnesses and a significant amount of evidence. And the trial court concluded that the records that are sought are not public records. There was no public function transferred by UCF. UCF did not create the journal. UCF does not regulate or control the journal. And UCF has no substantial financial interest in the journal. And as we all know, the journal is no longer even at UCF. The trial court did not abuse its discretion in making those factual findings, and I think it's important to remember that for the factual findings, that is the standard to be applied. The trial court concluded that every single factor and all this evidence went against these being public records. However, even if the court were to disagree and find that somehow these were public records, we believe that Becker failed to preserve the issue by failing to move the USB drive that was at trial into evidence, failing to seek to move it in, or if an objection was sustained to proffer it. There is no way for this court to review those records, which the unrefuted testimony shows contains confidential, protected information under state and federal law. As the court is well aware, based on the questions, the starting point is the City of Clearwater case, which shows that the location of the record is not what matters. We have to look at what the record is. And there has been a significant amount of talk today about what these records are, and I think I will...
Do you think Schwab is applicable to these circumstances?
Well, first I'll say that I think there is certainly nothing wrong with, if anything, if it's not applicable, at worst, the trial court did more work than needed to be done. The trial, as the court, in Judge Edwards' opinion, has recently remanded a public records dispute for the trial court to perform the Schwab factors. In that case, the trial court didn't think it was necessary. If anything, the trial court has given this court an outline of multiple ways that can be affirmed, including the Schwab factors. But yes, I do think the Schwab factors are applicable because if you look at the City of Clearwater opinion, the location of the records is not what matters. So if we take away the location of the records, then we are left to see that these records are not records of UCF. These records belong to the journal. They belong to the owner of the journal, whose counsel is here. And therefore, that is why we look to the Schwab factors. We look because...
How would you respond to the argument about the use of graduate students and the negotiation of the professor's salary in terms of reduced teaching load in return for his editorial functions at the journal?
I would first say that the evidence did not show, and it actually contradicts, that the reduced teaching load was for the service to the journal. The dean testified that the reduced teaching load is something different. Things are given to different professors during the negotiation when every professor comes in, and in order to attract top professors, they have to give those things. But in this case, it was not. The evidence said that if Dr. Wright, Professor Wright, stopped working on the journal, his benefits and his employment and his tenure would not change. There was multiple people, including the dean and his department chair, said that it would not be impacted. And while outside of the record, we can say, because the court could take judicial notice, that he is still an employee of the University of Central Florida, it did not impact it. So the unrefuted testimony shows that this negotiation was not to work on the journal. It was just a benefit given to a professor, much like the testimony shows that UCF gives such benefits or different benefits to all professors.
Whether it was specifically negotiated or not, the fact of the matter is that he did journal work on company time, you might say. Is that right? I mean, he did journal work on company time. He got assistance from grad students, that the subsidies of which came from the university. The physical needs of his operation were provided by the university: emails, computers, office space, electricity, that sort of thing. I understand that the publisher did the physical publishing, or I don't know if it's a digital or a paper document, but they actually published it. But what else was there, other than the actual publishing, what else was there that didn't occur at UCF on company time with company resources?
Well, I'd first say that the trial court found that the testimony established that the majority of the work by the graduate assistants was done at their house or apartment, whatever the case may be, on their personal laptop. So it was not done on UCF property. I would also point, with regard to your first question, Dr. Wright, on company time, I think semantics, but he testified that the majority of his journal work was done after hours because he's a busy man and he's all over the place. But I don't think the fact that UCF allows a professor to use their space there to do whatever they want and give a graduate assistant to be an assistant. UCF did not assign this graduate assistant to work on the journal. UCF didn't assign this graduate assistant to do anything other than whatever Dr. Wright needed to support his professorship and to support...
I have one of my staff attorneys do some research so that I can write an article for the Florida Bar Journal. Is that a transaction of public business that would make the communication, say emails back and forth between my staff attorney and me, would that...
I would say no, Your Honor. I believe, based on the Supreme Court's opinion in the City of Clearwater, that you are governed by slightly different rules, perhaps, but I think the court said that the same intent is there. But no, I do not think that would change anything. Just as if a first DCA judge were writing a treatise, or a Florida Supreme Court justice were writing a memoir, and they were corresponding with their publisher, and they happened to use their Florida court's email address, or if they were discussing with their wife an issue with their child, I don't think that makes it a public record. The question is, to quote the court, to be a public record, the emails must have been prepared in connection with official agency business and be intended to perpetuate, communicate, or formalize some type of knowledge. And that's not what happened here. There was no official business done here. And while a lot has been made over travel and a tax ID, the travel was to the American Sociological Association conference for that purpose. There happened to be a dinner with the SSR Journal editorial board on that trip, but the purpose of the travel was to go to the conference. In regard with what was called a slush fund and a tax ID, the evidence indicated that it happened once, and UCF said that it could not happen again. So there is the facts here show that UCF had no interest in this journal, no control over this journal. The professor was not required to be working on this journal, nor were these graduate assistants, who were also, during the period of during their time, doing other things. The appellant didn't call any of these witnesses, these graduate assistants, as witnesses or depose any of them, so we don't know exactly when they were doing that work and what else they were doing, and there's nothing to refute the evidence that is in there from Dr. Wright that they were doing other things for him, and the testimony that he gave that he was doing a significant amount of other things and still does so. So I believe that these are not public records because they had no purpose related to the University of Central Florida. The business was related to the journal, which is unquestionably owned by a different entity. I mean, the journal started at Johns Hopkins, went to UMass, went to Tulane, went to UCF, now is at UNC. This is not a business of the state of Florida, this journal. It just happens to be a journal. And on that point, it not being part of the official business of the state or its university, it would put the public universities of the state at a severe disadvantage if they were no longer able to allow their professors to do such things, because the peer review emails would become.
That's a public policy analysis, and that's a legislative. We have public records when people are applying for the presidency and deanships of our university system, and there's been much discussion about whether that's a good thing or whether we lose candidates because of it, and the legislature is well aware of that, and they leave it as it is, and so that seems to be a legislative function, not a judicial function.
Well, and I agree, and I wasn't saying that this court should legislate but I think it is worth noting that if public universities were not allowed to allow their professors to do this in the state of Florida, the public intent of the legislature in allowing these universities to exist would not be served, because schools like Stetson down the road would be able to do so, whereas UCF wouldn't. I think another case that I'd just like to briefly mention is the Butler case. 4th DCA talked about how the mayor sent an email. The email contained articles or whatnot that the mayor had written. We don't know who they went to because they were in the BCC line. And the 4th DCA affirmed the trial court's finding that the mayor was under no statutory obligation to notify friends and supporters that a column had been published, and that the city played no role in his decision, in the decision to send the email. The same would apply here. The university, the work on these emails, which are again not in evidence, but was not done for a purpose of the university, and the university played no role in doing these things. Again, the majority of the work was done by the grad assistant on their laptop at home, in addition to other work that the grad assistant did for Professor Wright.
So you wanted them to proffer the emails that you wouldn't give them?
Your Honor, they were provided in the courtroom out on the day of trial or the evidentiary hearing. It was made known on the record, and the witness stated, or a lawyer stated, that the flash drive with them was there if anyone wanted them. And we believe that at that point, they could have been, at least put them under seal so that this court could have had the opportunity, if it so desired. Because in the, I believe in the city of Clearwater, it was held specifically.
Until that point, you had resisted giving them up, right?
Excuse me, Your Honor?
Up to that point, you had resisted turning them over.
Well, I believe that the correct procedure would not have been to turn them over. It would have been to give it, for them to ask the trial court take them under seal. And I don't
Right,
think.
I'm just saying that all that occurred the day of trial, and they didn't have any time to give it any thought.
Correct. I believe that is correct, Your Honor. But I just go in the city of Clearwater, quote, "It was the Times' burden to request an in-camera inspection of the email designated as personal if it intended to prove that the employee's designation of each email as personal was incorrect." And in that case, they held that it was waived. And if I could just say one other thing, Your Honor. There was a discussion about the NCAA case, which was actually a first DCA case. And I don't agree with my friend over representing the appellant that that case was much further from the business of Florida State University. In that case, the transcripts were reviewed by FSU's outside counsel for the explicit official purpose of preparing FSU's appeal. The records were used for that purpose, and it was exclusively for the business of the university that those, so I think that case is a different scenario, and I would disagree on that, and I'll yield the remainder of my time.
Thank you.
Thank you.
Good morning, Your Honors, and thank you for allowing me to appear here. My name is William Strong. I'm appearing on behalf of Elsevier, Inc., and you've allowed me to appear pro hoc vice, and I appreciate it. The fact that I'm here at all, down from Boston, is an indication of how seriously my client Elsevier views this situation.
Could be a reflection of the weather in Boston.
That is true, Your Honor. I was very glad when the scheduling came through. I was very happy to come down for warm weather. Elsevier finds itself in the position of being told that documents that it had every reason to believe were private and confidential documents somehow have magically turned into public records. These documents are both proprietary to Elsevier, and they are of an extremely sensitive nature. They include not only Elsevier's own confidential information, but they include information that was provided to Elsevier by reviewers all over the world who relied upon the express promise that these materials would be kept confidential. All that information is at risk here if this court were to overturn the decision of the trial court.
Again, my difficulty with that is that gets into a public policy argument, and that seems to me to be a topic of conversation with the Florida legislature, not with us. What we're looking at is the language of 119 and how we apply that.
I understand what you're saying, Your Honor. I think, though, that it does accentuate the proprietary and confidential nature of this information, and I think this court can take into account the fact that documents were entrusted to Elsevier with the expectation that they would be kept confidential. That's part of our trade secret argument as well.
Did the trial judge ever review any of these documents in camera to determine whether, in fact, they were confidential or proprietary or trade secrets?
He did not, Your Honor. We brought a thumb drive to the court. I announced in court that this was available for the court to inspect if the court wished to. The judge did not. And these documents were not subpoenaed, by the way, by Mr. Becker. We brought them voluntarily should it become necessary for them to be inspected, and there was never any inspection.
I remember a reference to 15,000 emails or at some point.
Yes, some astronomical number. I don't know what it was.
Was that the thumb drive that had the 15,000 emails on
Yeah,
it?
that's correct, Your Honor.
Would have been quite an undertaking.
It would have been quite an undertaking. I'd like to discuss for a moment the contract, because I think the contract has to be the starting point for the analysis of this case. The documents at issue here were provided to Dr. Wright only because of and pursuant to the contract and in reliance on the contract. The trial court found that the contract was a personal service contract, And that is clearly correct. Had it been a university contract, it would have been vetted by university counsel, it would have been stamped as approved. None of that was the case. In our brief, we identify many statements in the contract that indicate its purely personal nature, such as the services provided by the editor hereunder are of a personal nature, such that the editor may not assign this agreement without the prior written consent of the publisher. The agreement is shot through with references that make it clear that it is a personal service contract. And this simple fact, it seems to me, should be dispositive of this case. The documents at issue here, as I say, came into Dr. Wright's possession only because he had signed this contract for personal service. Elsevier hired him to edit a journal that it owned. It had had relationships, it had had a relationship with him over many years. There was a great deal of mutual trust between them. He was at the University of Massachusetts, and he edited the journal there. He took it with him to Tulane, and he brought it to University of Central Florida. But at no point did Elsevier believe that it was contracting with anyone other than Dr. Wright himself. There was a lot of discussion, there's been a lot of discussion here about all this so-called consideration that was provided to Dr. Wright. None of that was aware of what was in the knowledge of Elsevier. There's nothing in the record to indicate that Elsevier was told any of this information. And so Mr. Becker tries this hurdle that this was a personal contract that says these documents are proprietary and confidential. Mr. Becker really can't get over that hurdle, and so he tries to slide around it by arguing that somehow this was official business, these were assigned duties. But the record does not support that these were assigned duties. In fact, the entire concept makes no sense. How could it be an assigned duty? How could the university assign to Dr. Wright the duty of being hired by Elsevier? That decision was entirely within Elsevier's discretion. How could it be official business for the university to say, you must go and work for the profit of an outside private commercial enterprise and receive a private stipend for doing so? How is that official business? It cannot be. If it were, a party in Elsevier's position would never have any idea when it was entering into a contract with anybody who happened to be a university employee that it was engaged in official business. If this were a regular book publishing contract, which, like editing a journal, is something that is expected of university professors. They're expected to write books. In fact, they don't get tenure if they don't write books. And they're expected to use university resources, the library, their emails, their graduate students who will assist them in research. They're expected to use all those things, but is a party that enters into a contract with a professor to publish a book, is that party now engaged in official business of the university?
Counsel, you've exhausted your time.
Thank you, Your Honor. I will rely on my briefs for anything I haven't said here. Thank you very much.
Just by way of rebuttal, I would remind the panel that this is at beginning, middle, and end a public records case. And the question before the court is whether or not the Public Records Act was violated in the response that Mr. Becker got to his request. The record reflects that he made a very broad request for all documents, and it was including but not limited to. The attorneys for UCF reviewed that, and if they construe that as limited to, then that really is not on Mr. Becker. But it was a request for records. All the court has to do to find out that the Public Records Act was violated is to look at the trial exhibits in this case. The trial exhibits contain responsive records. Mr. Becker got 0 records. Not a single record was given to him. No search was made of the emails by Dr. Wright or Elsevier or anyone else. The request was rejected out of hand. The email between Dr. Wright and his supervisor making a determination of whether he should put the SSR journal on as outside worker on the conflict of interest form is a responsive record. The email correspondences between Dr. Wright and his colleagues where he's complaining that the university is not reimbursing him for his work-related travel expenses on the journal is a responsive record. Almost every trial exhibit in this case is a responsive record to the request. If you review the request and review the records that went into the trial court as exhibits, which were produced in the inadvertent production and which were ruled by the earlier judge just to be public records, Becker was not required to return them. This wasn't really a trial. This was a rehearing.
Who was the earlier judge? I think Judge Kest, it was Judge Kest that did the ultimate hearing.
Correct.
And who was the earlier judge?
Grisinkowitz, I think is how you pronounce it.
Griswitz.
Yes. He did the in-camera inspection. The hearing wasn't a scheduled trial. It was a motion to vacate and rehear, and so it's procedurally somewhat unclear. The in-camera inspection was done initially, and at the beginning of the hearing, in the record, it reflects the procedural confusion, and it was requested by plaintiffs, by myself, on behalf of Mr. Becker, to maintain the ruling from the in-camera inspection. There was the evidence that was taken there was not vacated at any point during that proceeding. That was already in the record. They have subsequently disappeared, and we requested that they be placed back in the record, which request was denied, has been resisted, put it that way. But at the beginning and middle and end, this is a public records case, and of the record exhibits, there are responsive records that were not provided to the requester, and that violates the act. It's really that simple. They're documents. We're talking about a very broad range of documents and a broad range of requests, and my opponents have elected to focus on a very thin sect of them, the things that they want to keep private, which I would argue are also public records. But if one looks at the trial exhibits, there were numerous responsive records that are clearly university business, that are clearly about the journal. They're about Dr. Wright's employment, his employment reimbursement, his employment travel, that are responsive records. And the judge that did do the in-camera inspection concluded that overwhelmingly. It appeared to us that that would be part of the proceedings because it was a motion for rehearing. The other thing, the court accurately states the policy arguments don't have any proper place here because that's a legislative question. And I think it's also clear from NCAA that government agents cannot contract away and cannot create a private expectation of privacy and avoid the act.
Thank you, counsel. Thank you both. We'll take a break and invite counsel to join us if they choose to, and we'll be back in just a few minutes.